I will be explaining about the Delict, the whole thing about the Delict slowly so that you can get it. Then when we move slowly. Although today I was saying that we can start with F5, but I think that this week I have to start again to explain so that you get the message about the deleted. Because you can see now we have, as I've said before, that we have a different types. We have PVLs, by the way. We have PVLs, and all those PVLs, you do them. You know, some do them as one, some do them, as separate. Like you need you do them as separate. Some do them as one. You know, we have a contract. We have a Delict. Sorry, not Delict. We have a Delict. Let me put the mic well. And then we have property, and we have enrichment. Yes, those are the four modules. Now, contract, Delict, property, and enrichment. Now, when we deal with a Delict, it means that we are dealing with what? That would be the question. What are the difference in all? Because some, even when they write a book, they write the book that contains all these four. So on the contract, of course, we deal with the content. Here we deal with the content. So we look into the content of the contract, the material aspect of the contract. So we deal with the content, something that is inside the contract. So here on the contract, we specifically deal with the content, right? So we check whether there was a signature, whether the contract was certain, whether the contract was firm, whether there was a consensus, whether there was a will theory consensus, or whether the contract has come into being. So we deal with the material aspect of the contract, with the content of the contract, right? Whereas on the Delict, because this one doesn't arise out of the contract, of course, it arises out of the damage. So this one, we arises when there is a damage. There must be a damage. There must be a damage. Not the damage out of the contract, but the damage. Remember, there's a difference. This one, we deal with something we call a contractual damage, which mostly is a breach of a contract. Is different. It means that you failed to honor the contract, will lead into the breach of a contract. Whereas on the Delict, we deal with the damage, where you have damaged someone property. If you damage someone property. So here we focus on the patrimonial loss mostly. And also we deal with those that are non-patrimonial, such as, everyone has a right to physical integrity, right? So if everyone has a right to physical integrity, it means that if you defame someone, you can sue someone for defamation. Those are the other things that we deal with, right? Now, you can see the difference between the contract and the Delict, right? You damage someone's car, we come, I go to court, and then I use actual equivalent action so that you can compensate me for the damage. Contractual is when you have breached the contract. You should have honored the contract. You decided not to do so. So the compensation will be stemming from the fact that you didn't honor the contract. Now, when we go to property on the other side, property doesn't deal with the content of the contract. Although, of course, whenever there is a transaction of the property, there will always be a contract. But here, the property deals strictly with the whether there was a delivery or not. So it deals with the ownership. To prove that, it deals with the ownership, whether there was an ownership, change of ownership or not. So it deals with the ownership, which believes that the ownership should be changed in the deeds office, right? So it followed Deeds Act. When you change the ownership of the immovable property, did you go to, did you approach the deeds office and change the ownership? If not, then there's no ownership, right? That is the ownership. So it doesn't deal with the contract, whether you have signed a contract with someone, say, I'm selling you the car. For example, if I said that if you sign, let's just say you signed a contract right? I'm saying to you, I'm selling this house, right? You said, okay, here's the contract. I said, okay, give me contract, I want to read. Then I give you a contract, you read it and said, wow, I'm loving it. Your house is 400,000. Well, I'm signing. I'm signing. I'm buying it. Then you sign the contract to show that you're buying. Now, you sign the contract of a sale of a house, right? And then after signing, it means that you have honored, you pay to honor the contract. But you have not yet been owner because you have not fulfilled this one of ownership. The ownership is when the person who's selling you go to the deeds office and change the ownership. You see, that is the differences. Now here you can actually see how. So it means that even when we deal with the servitude, it means that the servitude should be registered, right, as a limited real right in the deeds office, whether those were. So you can see how the property it is. Now we come to the enrichment on the other side. Enrichment has nothing to do with the content of the contract, right? It has nothing to do with the content of the contract. So it means that if you have signed a contract that says that you'll be getting, no, let me write it here. Let's just say you signed a contract saying that you'll be getting 200 rand, okay, weekly. Then they do mistake and send you a 400 rand. It means that you know, according to your contract, that you must get 200. So it means that when you get 400, you must notify them about these changes so that you know. If you fail to that and they realize later that they've sent 400, it means that now we deal with unjustified enrichment. You have enriched yourself. Yes, the contract said you got 200, but they sent more, maybe by mistake. And you should have realized that this is not the amount that I contracted. So when you get 400 rand, it means that you have enriched yourself. Right? Okay, let's just say you signed a contract of the house. Then you go to the deeds office, you find that you have changed everything as well. But you find out later after buying that the owner said he is owing nothing, whereas he's owing ESCOM. What you must do in that regard, it means that you were misrepresented. There was a misrepresented. When there's a misrepresented, we go to the effect to raise a stopper on the other side. That no, the other person was misrepresented, right? The other person was misrepresented. So of course, there is a stopper which will deal with that. So here, when you sign the contract, you were misrepresented. saying that I own, maybe it's a contract for, maybe it's a contract of marriage. You want to marry someone in community of property. And that person said, well, I own. This house belongs to me, whereas it doesn't belong to him. So it means that you are misrepresented. The person has misrepresented himself in a way that he wants you. There was an unduly influence so that you can get into the marriage in community of property. Now, it means that you raise on the other side, he says, stopper, where third party has been misrepresented. Okay, now you can see here that even though you send money by mistake, it is also amount to unjustified enrichment. Even when you have helped someone with money, whereas it was a necessary case, you can get that money later through enrichment. Right? Now, those are the differences between contract, delict, property, and enrichment. Now you can see when you get into examination, when you spot these differences, even when you go on with your life, you will be able to understand when the dispute is about the delict, when the dispute is about the contract, and when the dispute is about the property. Because here the dispute will be about who has ownership. It will not be about who has, whether the contract, what the contract says. Right? Okay. Now let's start with this one of a delict, which we are here for. A delict. As I said, that the delict is when there's a damage. Now, you don't go to court and say that there's a damage, and they said, okay, so yeah, I want compensation. There's a damage, and then somebody must pay for the damage. Somebody must pay for the damage. So in order for them, the court has to figure out through the elements. So there must be an element in order to determine the damage, whether there's a damage or not. So those elements, number one, they must go for the conduct. They must check whether there is a conduct, right? And then on the delict, one of the things is that the conduct is only being done, as I've said, by natural and juristic. Natural and juristic. Therefore, it means that the animals cannot act for the purpose of delict. So that is another different story. So we'll start with the conduct of the animals, because animals does not act. Number one, we'll just state by, when we talk about the conduct, we'll firstly say that the conduct must be voluntary, right? It must be the voluntary done by natural or juristic, right? Those two must be voluntary. It can be commission or omission, right? A positive act, omission, right? Now, we'll talk about this one now when we are done. Now, firstly, let's deal with before we even come to the voluntary, let's deal with the fact that animals cannot act for the purpose of delict. Now, let's start here on the animals cannot act for the purpose of delict. Right? Now, let's say that, let's just say Jimmy is walking around the park. The wandering dog charged at him and bite him, right? And then Jimmy discovered later that dog belongs to Danny. Now, on this one, you can see that you are just walking around the park and there was a wandering dog charge at you and then bite you. Now, later you discover the owner of the dog, right? Now, here on this situation, there is a violation of your right, right? Your right has been violated. You have been injured by Dennis' dog. But Dennis' dog was a wandering, right? It means that you find that we cannot say that why it is wandering, because it can happen that the dog can jump over the fence and wander around. So in this instance, Denny, we cannot say that he foresee the possibility of a harm in this instance. But now the question will be, because the dog cannot act for the purpose of delict, can Jimmy able to hold Danny liable? Now, in this one, through the elements of a delict, he may not, but there is there is a remedy that has been put into the place in such circumstances or situation. Why? You remember this type of a scenario is a scenario of a strict liability, right? Strict liability meaning there is no fault on the part of owner of the dog. There is no fault. Remember, fault is about fault has a negligence and intent. So there is no fault on the part of the owner. There is no fault on the part of Danny, right, to hold Danny liable. So it's a strict liability. So on this type of a strict liability, they have come up with what we call exio di papuri. Yeah, exio di papuri. Exio di papuri is the one that can claim. And then when you go to your book, you'll see the requirements of exio di papuri and so on. So when you get into examination, don't forget about this one, right? When there's no fault on the part of the owner, it's a strict liability, and then you can only claim using exio di papuri, so that Danny can compensate Jimmy for damage. Now, what if Jimmy is walking around the park? Then now, it's no longer a wandering dog. Now, let's just say that Danny then incite his dog to bite Jimmy. Now, if the dog successful in biting Jimmy, what will happen in this one? Now, this one now it changes. Let's just say now the dog bites Jimmy. Him, right? Now let's put this one. Now, this one matter is no longer a matter of a strict liability, because although the dog cannot act, but here we have a owner of the dog, Danny, who incite his dog to bite. So in this instance, we can say that Danny used his dog as an instrument to attack. So when he used this dog as an instrument to attack, it means that we can say that we take this dog and then we impute like it's a Danny action, right? So we'll say that this is Danny who acted. So for that one, we'll say that the dog has acted for the purpose of dealing, but this will be Danny, because the Danny is the one that wanted the result. And in order to get that result, he used his dog. So he used the animal to achieve that particular result. So he acted for the purpose of delict. So Danny can be held liable for that. Now, that's a conduct. That's a conduct. Now, let's move to talk about the voluntary. The conduct must be voluntary. And then we said that it can be commission or omission. Now, let's start with omission. Omission is that the people have a duty to act. Someone in the other book said that the people have the duty to speak. This duty means duty to speak, duty to act, duty to speak. Yes, that is the duty that we have. We have a duty to act and a duty to speak. So if you find, if you work in the ESCOM and you find some cables hanging and you said nothing, you can be held liable. Yes, you can be held liable because you work in the ESCOM, you know about the danger of hanging cables, yet you said nothing, leading to omission. Right? This is like a municipality. Let's just give by example by municipality. Right? Municipality decided they are passing every day. They are passing every day, but they didn't care about the robots. Right? They decided not to fix the robots. The robots are off and they never fix. 1 year, boom, down the drain. The robots are still not fixed. Then one day there's an accident. What happened is that the municipality has a duty to act. They failed miserably to act. Right? Even if in Soweto there was a child who fell into the storage, So who should be blamed on that one? Because the child fell into the drain, who should be blamed? Municipality will not be blamed if there were people who removed maybe the top of the storage, maybe, and municipality never bring into the attention of municipality, right? Even if the ESCOM is coming to fix electricity, where they think that they can come back tomorrow and fix, they must cordon off that area to prove that they are working. Even the construction, if they are working somewhere, they must have a tape at least to cordon off the area to say we are working here, right? Don't come, we are working here. Unless if you'll come when you are seeing the tape, and then we will talk about that one when we get into the contributory negligence and apportioning of damage. We'll talk about those one. But for now, we are still on the omission, where you have a duty to act, duty to speak. You decided not to do anything. Now, the case about the police officer. Now, that police officer was off duty. When you are off duty, you'll be thinking like, I'm off duty, I'm not working. Then there was a crime that was happening, and he decided not to take any action because he was off duty. So he was held liable for omission, because when you're a police officer, whether on or off, if you are a nurse, you find someone ill, in the taxi, it doesn't matter whether you are off or on. You are a nurse. It's your job that you try to check up on that person, and if there's a medication, you prescribe such so that the person can get the help. So the person can just suffer from seizure. When you are a nurse, you just pass like there's nothing happening. It's your duty. All right? Okay. Now, since you understood, let's move on. Okay. Now, we come to the issue of wrongfulness. Now, before we go to the wrongfulness, one of the things that you must know about conduct is that, of course, there's always a ground of justification, right? Where you can justify your conduct. There is ground of justification where you can ground by relying on the same automatism, right? They serve as a ground of justification, saying that, yeah, I know it was my conduct. At that time when I was falling, that time when I crashed with one cars, I was suffering from epileptic. I had a seizure at that time. I had a seizure and I couldn't control myself. So my conduct was involuntary. So in the saying is that you are proving that my conduct was done involuntarily. No, involuntary means you were not controlling your muscle, your movement. It was just being done involuntarily because you were suffering from a particular disease, which is saved as a defense. You know, if you are driving a car, you suffer from stroke, then it's a defense. Even if you cause an accident killing people, but you suffered from stroke, so there's nothing you could have done. But it will be it will be different if now you decided not to take medication when it was prescribed that you may suffer from epileptic. You decided not to take that action. You decided not to take a medication. In that one, you'll be negligent. And when you are negligent, you will not able to prove the same automatism. It also happened in what we call libera in causa. Say libera in causa. What happened here is that you go to the tavern, get drunk, and then you try to drive back home, and you caused an accident. Because you were drunk, you will rely on the fact that my conducts were involuntary. I was so drunk I couldn't see anything, so my conduct were involuntary. They said, yes, your conduct was involuntary, but you placed yourself in the situation. So libera in causa is when you place yourself in a situation where you have to act mechanically without a movement, without controlling your movement. You know, some in other words, some they can desire the results by the fact that so libera and causa, by the way, is an intent. You know, someone can be like, I want to beat that guy, but in order to beat that guy, I have to pass through the tavern drinking so that I can get some energy to beat that guy. So you desire the results, but you have to go and drink. So when you come back, you cannot rely on the fact that I couldn't control my movements and so on because of the libera in causa, right? So that is libera in causa. So involuntarily, you could not prove because you cannot rely on the same automatism. Now we have many cases which are placed about whether you have suffered epileptic, sleepwalking, and other things. There's many there. You can go and check it. Now let's move on anyway. Now we come to the issue number 2 of a wrongfulness. You know, every day they said that you must be the wrongfulness. Wrongfulness nowadays has been replaced with unlawfulness. Unlawfulness. So it depends, but most of the people nowadays use the words unlawfulness. You know, so it means that your conduct should be wrongful. Yeah, that's element number 2. Your conduct should be wrongful. How it should be wrongful? Number one, we check the subjective right. Everyone has a right, as I've said. The right like a physical integrity and other rights. So when you violate the rights of the other person, it means that you have violated his subjective right. You know, if I own the house, you come and committed arson, you have violated my subjective right, the right of ownership, because you have destroyed what I own. So that is the subjective right. Now, they check first the subjective, whether you have violated the subjective right. Then if it is, then it said, okay, you have violated it. Number two, they also now go to the test. Now, the test is based on two. We have a test for we have a traditional and a new approach. Now, of course, traditional is based on the reasonable person. Now, remember, the traditional approach is different from negligent. As I said, negligent is based on the, on the whether the reasonable person foresee the harm and take measure to prevent the harm. That is a negligent. This one is a reasonable person based on the legal conviction. So it means that it's based on the community morals. So what the community can say about it, the community can say, well, drinking alcohol and driving is not moral. That one, it's not moral. It's immoral. So now it means that you were wrong, right? Drinking alcohol and drive. They said that no, it's immoral. So yes, reasonable person is based on the legal conviction. It's based on the community morals. And it was decided in the case of what was that case of? Now I'll think about it. Forgot the case of that one of a test. Now in this one, we talk about a lot of things, right? We talk about omission in the wrongfulness, or also look at the justifications. Now, today we will only talk about the justifications. So others will continue with them. Now, when we go to the justifications, the justifications of wrongfulness is not saying automatism to rely on the same. This one is based on numerous factors. Number one, it could be about the private defense. I was defending myself. I defended myself. So it was for me, yes, I know I've done that one, but I was defending myself. Number two, if there's no, you can say that, oh, that was necessary. Necessity. Necessity is when you violated the third party. When you have violated the third party interest. And private defense on the other side is when you, sorry, let me drink a little water. It's when you are defending yourself from aggressor. So you should be defending yourself from aggressor. Here, you defend yourself from aggressor. Whereas here you violate the third party interest. Now, you must know that here on the private defense, it must be imminent. Therefore, you cannot be beaten at a tavern, then you go home to take a weapon and come back. It's no longer a private defense. However, there was a guy who was mugged. Go home, take a knife, come back, and then stab the guy who mugged him, and then he take back things that they were taken. And the court said it's still a private defense because the guy was poor, and the only means he was doing all the means he has to get back what was marked. So they say that it's a private defense. But actually, it was criticized because in the private defense, they made it clear that it should be imminent. If it's no longer imminent, then it's not a private defense. Now, let's look at this situation, right? If we say that Jabu pointed a 9, Jabu dog bite Jimmy while no, let's just say that. Let's just say Jabu dog bite Jimmy. Now, in this one, kill the dog. Now, Jimmy takes out gun and kill the dog, right? Now, in this one, it means that Jimmy, if Jabu wants to hold liable Jimmy, Jimmy will rely on what? Jimmy will rely on necessity. That is because he violated the third party interest, but it was necessary for him to defend himself, right? And then if now we put this scenario saying Jabu now here incite dog to bite Jimmy. Jimmy takes out gun and kill the dog. Now you can see that Jabu is the owner of the dog. So since Jabu is the owner of the dog, it means that Jimmy was defending himself against the aggressor, because Jabu is the aggressor who is using his dog as an instrument. Now this falls under private defense. Don't forget it. This falls under private defense. Now let's just say Jabu inside the dog. Now we find that, let's just say the dog belongs to Mary, right? The dog, Jabu does not own the dog. The dog is owned by Mary, but Jabu inside the dog to bite Jimmy. If Jimmy kills the dog, it means that Mary will have to institute a claim against Jimmy. Jimmy will rely on necessity, saying that it was necessary for me. Now, those are the questions of the dog, which you know now when you get into examination, it becomes much more easier to say that this is a necessity, this is a private defense. Now, private defense does not only apply to this particular situation. Private defense also apply in the situation where you violate the third interest, even though it was about you being alive. For example, let's just say that Inkabi wants to kill Jabu after missing Jabu with 2 bullets. Jabu used Mary as a shield. Then Inkabi shoot and kill Mary. Now, in these instances, we can see that we have Inkabi who wants to kill Jabu.
But Inkabi missed some few bullets, and Jabu manages to maybe crouch to Mary and then use Mary as a shield. Now, Inkabi on the other side shoot and kill Mary because Mary was being used as a shield by Jabu. Now, in this instance, of course, the family will try to help Jabu liable or the state. Jabu will have no choice but to rely on the necessity. Jabu will say that, well, it was necessary for me to use Mary as a shield to protect my life. To protect my life. Yes, it was. There was a case of a person that they were on a boat and the boat was drowning because of the weight, and that guy pushed another guy out of the boat and he survived. He relied on necessity, and it was proven that necessity could be applicable because it was necessary for him to kill other person for his survival. Right? So it's not mercy killing. It's just that you have killed someone in the situation where you have to kill someone to survive. So Jabu had no choice but to use someone as a shield for his survival, so he can rely on necessity. Okay. Now, I hope that you understood. Now, we also have something we call provocation. Provocation is when you have been provoked by other person through insults and others. Person decided to insult you, and then you get angry, then you injure that particular person. That's a provocation. In court, you can rely on provocation, right? So yes, those are the things that you can rely. But there are many things that you can rely on and rely on. It's just that I don't want to talk about everything in one day, you know. So we have talked about provocation, which now you could see. We've talked about the private defense necessity. We have talked about a lot of things, which means that we covered a lot. Now, I think that we'll stop here on the provocation. Then tomorrow we'll start. Wednesday. On Wednesday we'll start on the other justifications. Then we go down so that we finish up all this information so that we go to those examinations and able to answer them, and then we move on. So yeah, no problem on this Delict. We'll meet on Wednesday. Tomorrow I'll come back later and I'll be home around to 8. So it will be late. Yeah. So yeah.